Go for it, Jared. Let's make it
All right,
happen.
there we go.
All right, everybody. Thank you for tuning in for another episode of the Martin Eiden team's Ask the Expert series. Today is super exciting because we have a special guest host, Sean Wilson. It is his first time hosting this, and he will be doing this on a monthly basis while Alex takes a little bit of a well-needed and well-wanted rest. So Sean Wilson is here with us today, and we are going to be talking with Christopher McNerney, who is a civil rights. What was it again? I totally missed this up.
A civil rights attorney. Yeah, he's a
civil rights attorney. Civil rights attorney, which I'm really excited about, especially with everything that's going on. So Sean, I will leave it to you to take it away.
Well, thank you very much, Martin, and thank you for allowing me to host it. And I'd like to say that this is the 30th episode, so I'm super excited to have you on board, Christopher. And I'm super excited to talk about civil rights law, given what we're currently going through at the moment. So I'd just like to start, Christopher, by you taking a moment to sort of introduce yourself to the audience and to tell us what you do as a civil rights attorney.
Sure. Thank you for that introduction, Martin and Sean. It's very much appreciated. So as they said, my name is Christopher McNerney. I'm an attorney with the firm of Eiden and Golden. We do workers' rights litigation. So we do civil rights, workers' rights litigation solely on behalf of employees. So not the management side, just the employee side. Our firm really has two buckets of practice. One, we represent individuals. If you're discriminated against at work, if you are fired because of your age, or even if you have a severance package and you want to negotiate it, we have an individual side that handles that aspect. And then I'm on the class side of the practice group. And what we do is we litigate large class actions, either discrimination or wage and hour, against employers to get compensation for a class of people or to affect systemic change. And in the best cases, to do both. And so what I specifically do is I litigate mostly these days large systemic racial and gender discrimination cases. So a company that has a policy that screens out people impermissibly because of a protected characteristic, something like that, or wage and hour cases as well. So companies not paying its workers the company is misclassifying them as exempt from overtime when in fact they should be entitled to it, things like that.
I just want to say everybody on my team is happily employed and are very happy.
It's funny, I get that reaction. My wife is in sales, and when I talk to like other managers, they're like, well, I didn't do anything wrong. So
Go ahead, Sean, I'm sorry.
So what is the state? What is the current state of employment law? Where do we stand overall with employment law?
Sure. It's an interesting question, and I was reflecting on it a bit in preparation for this. And I think the two main takeaways are that people think that they have more protections than they actually do, and people think that they have more of a right to sue in court than they actually do. So starting first with, starting with protections, the default presumption throughout the country, and especially in New York State, is something called employment at will. And what that means is your employer can fire you for no reason, but beyond that, they can fire you for a bad reason or even a mistaken reason. They could fire you for something they think you did, but you didn't actually do. The only limitation on this is they can't fire you for a protected reason. So they can't fire you because you're Black, or because you're a woman, or because of your sexual identity, or because of your age. It really is limited to those specific categories. And so a lot of times, people come to us and they have, for example, this concern of a free-ranging hostile work environment claim, where they say that my workplace is toxic and I want to sue them. And it may well be toxic, and your boss may well be a jerk. But in that specific case, unless it's an environment that's hostile because of a protected category, like it's hostile to you because of your race or something like that, you actually don't have any legal protections there.
So Christopher, let me ask you something on that. So in that case, do you need a number of employees to have that same allegation to form a class action suit? So, I mean, so does, I mean, you have one Black person who says, well, later on, a couple of months later, you have a second. So is that how you build a class action suit, with a number of people claiming the same sort of issue?
Yeah, it's a tricky calculus, because what you really have to understand through talking with the individual is how much of this is what's happening to this person. Like, do they have a racist manager? Do they have a sexist manager? Is this something that may be cabin and specific to them and someone else? Or is it something that might be more systemic? Is the promotions rating system something where the promotion system over factors in, qualities that are predominant, traditionally thought of as gendered male, and like under counts qualities like being a good team player, being a good culture fit. And whether, in that case, something like that could well have a gender impact, where it's leading to significantly less qualified female applicants getting promotions over male applicants.
So how do you, as a lawyer, what are you looking for to say, okay, I have a case?
Yeah, it's a good question. I'd say
that's a good question, Sean.
Yeah, it's either evidence of, so this goes into the two ways to prove a discrimination case. The first is called a disparate treatment case. And so that means that you were treated differently. So examples of how you were treated different than colleagues of a different race or a different gender, anything that goes to that could be evidence of individual discrimination. If it's more prevalent, it could be evidence of a culture of discrimination. Beyond that, you're looking at the policies and practices, and you're trying to figure out whether what happened to this person is something that likely is going to be replicated down the line. So just to give an example, one of the cases that I litigate a lot are criminal history screens. And basically, the theory goes that under Title VII, which is the governing federal act, not just facially discriminatory policies are legal, but also policies that have a disparate impact, even if they're neutral. So at this point, I hope everyone in America realizes that the justice system incarcerates African Americans at rates vastly higher than their proportion of the general population. So you have this fact that because the system is racist, you have African Americans being much more likely to have an arrest, conviction, or incarceration. And so if you have a screen that says anyone with a felony conviction cannot work this job, that is likely going to disproportionately screen out African Americans because of those statistics. It's just a statistical fact that like the disparities are so great. And, in our cases, we've talked to sociologists, we've talked to criminologists, these are just established facts. And so that's sort of an example of how a neutral policy, you can reasonably assume that is going to have an impact across a protected class of people.
So can you tell us what are some of the outcomes of the cases that you take on in that arena?
Yeah, I think it's usually a sliding scale of the change that you can affect at the organization and the money that you can get to the individuals, because you want to compensate people for the harm that they suffered. It's never a one-to-one proxy of this amount of money can make you whole for this amount of harm. But in our legal system, that's what we figured out is the closest proxy. So that's bucket one. Bucket two is systemic change. You want to make the processes more fair and lead to ways that more people who are being screened out disproportionately are going to get access to those jobs. So one of the ways that we do this, and I think this is a really rewarding part of the job because it leads to a win-win outcome with the employer, is that you hire subject matter experts. I'm not a subject matter expert on what changes a company should make to have less discriminatory policies, but they're out there. So you negotiate over process. You negotiate over, like, these are the people that they're going to hire. These are the studies that they're going to do. This is the process for proposing recommendations to change. And just like you negotiate that process, you get buy-in from the employer, and you can end up with a policy that, protects their business need of getting qualified individuals, but doesn't do it to the detriment of qualified individuals that are in a protected class.
So, and this is, I'm asking you personally, which do you think has a greater impact, to a financial reward or the systemic change? There's, a change for, I mean, because for me personally, I think, well, I would want change for everybody than just money for myself.
Yeah, I mean, sort of the answer I want to give, we want
22.
both.
Yeah.
But,
Right.
but that's something that we struggle with in our cases. And like, because ultimately as class counsel, you're fiduciaries for the class. So you're looking to do what is in the best interest of the class. And is it money, or is it opening up, the system so that more people have access? And on the, our clients are almost inevitably, they have suffered through these systems. They felt the harm, and so they want to change it. They're definitely concerned with that. And so I think that the change can have effects much broader than the specific class. And so that's such an important aspect of it. But I think, especially when you're talking about low wage clients, studies show that sometimes even just like a small intervention of money, a one-time intervention can be the difference between, being able to set yourself back up for success, not like going below the poverty line and not going into debt. And so those money interventions also have a value even beyond just like, we're getting you this chunk of compensation for what happened to you. And so like so I don't have a good answer. I think it's specific, but it's something that we're very cognizant about, sort of the interplay of the two and what's in the best interest of the class.
Okay. And one thing else I want to bring up, we sort of talked about something that affects African Americans across the board, but you and I spoke about something that affects women, and sort of you talked about we talked about a case in which there's sort of getting jobs, and I can't remember what it was. It may have been the fire department or something, and they were asking women to run sort of 200-yard dashes at the same pace in which men would, and that would sort of exclude women from that. What were we talking about? I can't remember exactly the details of it.
Well, I mean, you hit right on it. Some of our cases have also involved like corrections workers, but firemen, like that is like the original type of this case, right? These were like the 1970s civil rights cases that are still going on today. And basically the idea is that we all know that some of these jobs are very demanding, right? Firemen, you have to be able to lug this equipment up a burning stairs, right? And so that there are some legitimate criteria. But what's problematic is when you impose criteria that are not job related and they serve just to screen out a group that shouldn't be screened out. So in the case of our prison guard case, I believe the situation there, if memory serves, was that it was run a X meter dash in a certain amount of time. And that was a process that men were much faster at running it, and women were being disqualified. But when you look at the actual job requirements, when you depose the hiring managers, when you depose people who are actually involved in doing the job, you find out that you do not need to run fast to do this job. It has no relation to the job at all.
Right. I've seen a few security guards or prison guards. They don't necessarily look like the next Olympic runners to me.
And so a lot of times in these situations, it's just sort of stepping back and asking, what are we doing here? I think it's the same with criminal history screens, right? I think a lot of times they come from sort of this intuition that if we have access to this information about criminal history, we should use it, and it should be probative in some way of employment. But when you actually like dig down into it, the vast majority of criminal convictions, they have nothing to do with the employment relationship, right? It's like, it's not someone stealing at work that maybe you could find to be relevant, And so if you're actually trying to tie it to the job, it gets much more tenuous. And in fact, when you look at who's actually making these policies for the companies, very often it's like three HR managers in corporate headquarters who sort of just put it together based off of some gut feeling without really any inquiry into the actual methodology and what actually would pose a risk. And so I think a lot of what we're doing with these cases is sort of pushing back on these sort of common sense assumptions that don't really bear scrutiny, don't really make the employer a better employer or a safer employer, but do serve to screen out protected classes at a higher rate and are societally problematic for that reason.
But you guys not only worked for protected classes, you sort of, in some ways, I know you work at a social justice firm, and you're on the public interest committee.
That's right. Yeah.
Okay. And so that committee, though, does a sort of a broader sense of work for just beyond protected classes. So can you talk about that?
Yeah.
And the sense that I'm talking about the middle class and sort of legal, yeah.
Yeah, well, I think you hit on sort of one of the big, I guess the buzzword for it would be access to justice issues in our country. That, if you're rich, you can pay a lawyer to work your case hourly, right? We have expensive rates, it's very costly. But if you're rich, you can do it. If you're poor, you have access below a certain economic threshold, you have access to legal services, right? That you don't have to pay. If you have something that has systemic implication, you can bring it as a class action. But if it happened to you and you're in the middle class and you can't, or even when we say middle class here, we're talking like just a bit above the poverty line as well, in this wide stretch, you really just don't have an access to lawyers. You can't pay an hourly rate. You can't get a lawyer from legal services. And if it's not a big enough case money-wise, no one's going to take it on a contingency fee. And so what happens to these individuals? And this is an issue, I think it's beyond just employment law. It's an American issue, because this wide group of people effectively doesn't have access to lawyers. And I think that's really problematic, because when we think about it, I think as Americans, we all believe that if something truly wrong happened to us, we would be able to get justice. We'd be able to go to court and we'd be able to fight this, and hopefully truth would prevail. But this is one of the ways it doesn't. And this is one of the ways that you don't have access to the courts. We can talk about others like arbitration, but for this one in particular, that's one of the reasons we put together our public interest committee, of which I'm actually the chair now. And it's to really get those cases that on a pure dollars and cents basis, or a pure, we're taking this on because it's righteous, it wouldn't make sense to take, but we don't want this person to fall through the cracks, right? And so we take on those cases completely pro bono for that reason, to sort of get at basically the reasons why a lot of us became lawyers, helping people in these situations.
Wow, that's amazing, Christopher.
Christopher, you're a good egg. I just want to hop back for a moment. And you said that's why a lot of people become lawyers. Why did you specifically become a civil rights attorney? You could have practiced tons of other law. Why civil rights law?
Well, so I guess it started way back when, being a frustrated progressive in the latter Bush years and wanting to do something, not happy at my job. But then when I started law school, I did this, what was at the time called the Unemployment Insurance Clinic, where you help people who were denied by their employer unemployment insurance. And so I took on, as like a first year law student, this person's case where, I didn't know much about the law, but what they really needed was just someone to spend time, right? And so went through the file, represented them at the hearing, and got them their a real chunk of money that made this tangible difference in their life. And it was sort of that was my gateway into it, I'd say, because it was that initial experience of seeing that connection between my effort and helping and making this other person's life better, that I just sort of hit all the notes of why I went to law school and why I wanted to stick with it. And, I've stuck with it ever since.
So we talked also, when you and I prepared for this, we talked a little bit about sort of the ways around in which companies or HR people can get around paying overtime to certain employees, which I found very interesting, that, all of these sort of low wage employees, the way to get around that is to slap a title on them, and then you can have them work all of these extra hours under the title of management and still not pay them.
Right. I mean, I think this is the sort of the intersection of how we litigate for justice, I think, because like when we're talking about these are workers' rights issues, you know, and they really are civil rights issues because they're about not being paid what you're owed. And you're looking at who are our low wage workers in this country. You know, they're predominantly persons of color. And so when you're serving to underpay in these types of jobs, what you're doing is you're disproportionately hurting persons of color groups. And that's where I think the intersection really is. But as to the actual law, basically this goes back to the Fair Labor Standards Act, which I think was passed in 1933. And I'll note 1933, that was the last meaningful change in favor of workers as to their terms and conditions of employment passed in this country. It was in the height of the Depression. It was passed. And what it did was, for the very first time on a national level, it set a floor. It said you have to pay at least a minimum. That's the minimum wage. And it set a maximum. It said that if you work more than this amount of time, you should get an overtime premium. And I think it's really interesting to think about this in our current economic climate. And again, the fact that it was passed in the Great Depression. And one of the things that gets missed when you talk about regulation in these days is that there actually were employer-friendly reasons for this, right? Because first off, it prevents a race to the bottom. It says that, you know, like if you don't have a minimum wage, then if my competitor starts paying $2, then, you know, and they're being able to make their products at a much better, you know, cost ratio, then like maybe I need to depress wages even further. And at the other hand is it incentivizes employment, again, situated in the Depression. The idea being that if you don't want to pay people an overtime premium, you pay more workers, you hire more workers. And so looking at that overtime, that's a long windup, but just to be concise after that, looking at that overtime provision, the default presumption is that if you work more than 40 hours, you should be entitled to an overtime premium, usually time and a half. And so that should be for everyone unless you fall into exemptions, like if you're a professional, you know, because a lot of lawyers were in Congress and, you know, they thought themselves, you know, like, well, we're professionals, we should, we're different. But what has happened over the years is that the exception starts to swallow the whole. And employers realized that if you slap a manager title on someone, you can work them the same as an hourly worker, but you don't have to pay them overtime. And so that's where you start to get like assistant branch managers at your local bank or assistant store manager at the Duane Reade. These titles that seem managerial, but really the reason why you have that title is so that they can clean the floor or work the teller, and they can do it for a bunch of hours and you don't have to pay them the overtime premium. And so those are the types of cases that we push back on, arguing that is an incorrect classification. The term of art is a misclassification case. And so I think that's one of the big issues with wage and hour law that we litigate.
That's awesome. So my one thing is I don't have anything to track time, so I don't know where we are. How much time do we have left?
We got 7 minutes, Sean. You're doing, or 5, 7.
Okay.
Yeah, you're doing great. So, so Christopher, is it still also the $50,000 mark if you make over 50,000, or was that a law at one point?
So there's a salary threshold. It's changed a bit, so it's a bit complicated. But basically saying that, you have to be at that threshold, and then there's additional exemption, which is for high paid earners. I think it's at like 105 now, but don't quote me on that. It's something like that, where it's much easier to fall in the exemption. So basically the main ones are the professional exemption, which is basically you're a manager and you look at both the money, but you also look at, you know, do they actually have power to hire and fire? Do you actually have power to meaningfully discipline? Do you have things like that? And then the administrative exemption, which looks at, you know, are you that type of worker who's kind of special and has discretion to do the job? Is it something where, you know, you're really doing it yourself? It's like a discrete skill set such that, and the sort of the lodestar or orienting point of all this is there a reason why this job is something extra, that means that there are reasons why you don't need to be paid overtime. And like behind it is the idea that presumably you have a higher skill set, so you're more marketable, you have more of an ability to negotiate for a higher rate. You're not as sort of dependent on statutory protections to ensure that you can make a basic cost of living.
Got it.
So we have a few minutes left. I want to cover two more things before we leave. But being a lawyer, you sort of want to have, how has the pandemic changed what you're doing? As a lawyer, people sort of have the idea you want to go to the office, you want to sit and talk to, they want to talk to you face to face. They want sort of this, how is that different during this pandemic? How has technology affected what you're, or how has the pandemic affected what you're doing? And is technology able to help in that?
Mm-hmm, mm-hmm. Well, to start with, we're doing a whole lot more of this, right? A lot more video conferences. I think it's changing our work in a lot of the ways that it's changing other workforces, but we're just starting from a more conservative place where, you know, the default presumption was always like for a deposition, for if you want to try to settle your case, if you want to bring something to the court, it's all in person. And there's this like premium of doing that face to face. There are rituals to it. You know, there's rituals to how you argue in court, the way you're supposed to stand up, how you're supposed to button your coat, all those things. And it was just parts of how it was. And so it was parts of how it always would be. And that's had to change, you know? And I think the really interesting thing is how much we've all gotten used to it. You know, arguments on very substantive issues. I mean, the Supreme Court is doing it. These have all happened via video conferencing, and the sky hasn't fallen. People are still being able to settle their cases. You're still able to get information from a witness through a deposition. We're able to do all these things, and you're able to appreciate sort of the side benefits. I mean, I think the offices eventually will come back. There's something to be said for in-person communication. I think that's true, especially when, at least for lawyers, you're younger in the profession, and sort of like being able to like just walk into someone's office and sort of learn through osmosis. I think those are valuable things that that it would be good to get back. But beyond that, you know, I have 2 hours now to like watch my daughter, to cook dinner that I didn't have with my commute. And I think that's going to be something very hard not to keep.
So you mentioned the Supreme Court. How does the makeup of this new Supreme Court how does that affect what you're doing? Will that have any effect on what you're doing or your cases? I mean, is it a difference?
Yeah, I mean,
2 minutes, Sean.
2 minutes.
So
Okay.
I'll be very short. The short answer is it affects it, but it already was affecting it, and so it's just more so. We've had a majority conservative Supreme Court for decades. It is just now, it's always been a small majority, right? Such that if you have a judge who is willing to compromise, or you have a judge who this is their particular issue, they're willing to flip to the other side, and you can get maybe a okay verdict. Now, that's much less likely to happen. There's much less elasticism and in the court, and the judges there are much more conservative. And so I think that the net outcome of that is that, you know, as a progressive lawyer, your job is to avoid the Supreme Court to the extent.
Well, what can we do to change that as progressives? What can we do to change it?
Well, I think that's a very topical question, because I think the answer is right now, vote, especially if you're in a swing state, and vote for your senators, because nothing's changing if we don't take back the Senate. And I think everyone knows this, but because of some very troubling Supreme Court rulings in the last few days, casting doubt on ballots received after the election date, if you're thinking at all about mailing your vote, it might not be counted. It's crazy to say, but so vote in person or drop it off. That's the best thing you can do to protect your vote, ensure it's counted, and ensure change.
And 30 seconds, Christopher, packing the courts. Should we pack the courts if we take the Senate?
Well, I wouldn't call it packing the courts. I'd call it right-sizing the courts. If you look at the last time the courts were expanded, it was to match the
Jimmy
amount.
Carter.
Yeah, actually, it was in the 1800s. That was expanding. That was expanding the number of judges, which also is important.
Right.
When we're talking just about the seats on the Supreme Court,
Mhm.
it was to match the number of federal courts of appeals. At that time, there were 9. It was expanded to 9. Now they're 13. And so, like, if we want to fit with that historical precedent, we need to expand it to right size it to the size that it should be, given just the amount of courts out there and the amount of judges.
Wow.
Well, thank you very much, Christopher.
Yeah, this was a pleasure. Thank you both. Thank you all very much.
Well, thank you.
Thank you,
Martin,
Christopher.
you want to wrap it up, Martin?
Oh, sure. I'll do it. I'll do the wrap up. Thank you. So, Christopher McNary, thank you so much for helping us out with this. And Sean, you were awesome on your debut of being the host. So thank you, everybody, and tune in next week for another